Hey, 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 it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hope you guys are having an amazing day. This is in regards to James Harden, the NBA player who plays for the Houston Rockets. If you guys were not aware, he actually has a restaurant called 13 in Houston. But um, word on the street, according to yesterday's news, he has been named in a wrongful death lawsuit along with his restaurant 13. um, if you guys weren't aware, I believe back in 2023, six individuals were actually unalived by an alleged drunk driver who also passed away in the motor vehicle crash. And normally, and this is what we do when we have wrongful death cases, especially dealing with drunk drivers. The first thing we want to do now, I'm surprised that they didn't just came out and filed the lawsuit on it, but some law firms are totally different. But we always want to trace where the drunk driver came from. That's the most important thing. Did he come from a bar? Did he come from a restaurant? Did he come from home? Wherever we can pinpoint, if he comes from a bar, a gentleman's club, a restaurant, we're going after that restaurant, because that bartender should have known that this individual was too drunk to drive and should have made other arrangements. And I know what everybody's thinking. Well, how can you hold somebody else responsible? Blase, blase, blase. Unfortunately, you can. You can say something. Okay, you can say something. You can stop serving the individual. That's what you can do. Now, if you come back and say, "Well, I did stop, serving them and they went elsewhere," then, but you can sue the entity that continued to serve an individual who caused a motor vehicle collision. So I do want to pull up the complaint that was filed on December 6th in Harris County, Texas. And as I stated before, it was six victims who were unalived in this deadly crash. One of the individuals' representatives filed on their behalf. So here we have Cassandra Jackson individually and as representative of the estate of Taylor Jackson. I do believe that the other individuals who passed away in this crash were actually college students that attended the University of Houston. Very, very sad and unfortunate incident that happened. Now, I am assuming that they have tried to do pre-litigation, meaning that whoever came forward. So, for instance, Cassandra came forward and she worked with the attorneys, submitted medical records, medical bills, because I'm assuming that the EMS did come to the scene, and they possibly transported them to the the hospital where they were pronounced deceased. So you have to provide medical records, medical bills, funeral expenses, the death certificate, all of these things, and you send out a demand letter to these individuals. So the defendant here would be 13 Strikes, which is owned by James Harden and Team Harden. So to send a demand letter and say, hey, this is what happened, these are the damages, and they will demand a amount. If they refuse to pay out, then this is where we come to the lawsuit. So you don't want to do it, but prior to litigation, let's go ahead and let's litigate this. Now, the firm that I previously worked at, when we handle wrongful death cases, as soon as we get it, we're filing lawsuit on it. We're not waiting, we're not trying to negotiate anything prior to filing a lawsuit. So this is versus, as I said, 13 Strikes LLC, aka also known as 13 by James Harden and Team Harden LLC. Um so I want to see. So the claim for relief. So in accordance to Rule 47 of the Texas Rules of Civil Procedure, this claim is for monetary relief in the amount of $1 million, including a demand for judgment for all other relief to which plaintiff may show herself to be entitled, including but not limited to damages of any kind, penalties, costs, expenses, prejudgment interest, and post-judgment interest. And I also meant to say is that the drunk driver ended up unalived. So you have no choice but to there's actually several parties that you can go after. The entity that provided the alcoholic beverages to the defendant, but also if the defendant had car insurance, depending on what type of policy that they had, they can go after. Now in Texas, the minimum policy is $30,000. That's the minimum policy that you have to have on car insurance. Now if they had just the bare minimum, that's not going to be enough to cover all of the medical bills, um funeral expenses, if there was any damages to any of city property. So all of that, 30,000 is not going to cover that. So I am assuming that is why they went ahead and filed the lawsuit against the entity that provided the alcoholic beverages to the drunk driver. So the parties in this is going to be the restaurant 13 Strikes and Team Harden. I don't have to really do that. Jurisdiction and venue. The incident took place in Harris County, therefore they filed it in Harris County. All right, so here are the facts. Now, mind you, this is just one individual. I'm not sure uh, how the other families are handling this. Maybe they'll also file lawsuits. I don't know. I'm just going to keep out to see if there are any other lawsuits against this entity. But for now, it's just with Cassandra, who's the representative of Taylor. On November 11, 2023, Christian Daniel Herrera was an invitee at the defendant 13 Strikes LLC, also known as 13 by James Harden, located at 1911 Bagby Street, Suite 100, Houston, Texas 77002. Christian Daniel Herrera ordered and was served alcohol in excess of 13 by James Harden at 13 by James Harden. Christian Daniel Herrera was served alcohol beyond the point of intoxication that resulted in a blood alcohol concentration of 0.138. And let me see. Texas blood alcohol. I know this, but I don't want to say it and I'm saying it wrong. There we go. So yeah, I knew I was right. So the legal blood alcohol concentration limit for drivers 21 and older is 0.08. This individual's blood alcohol was 0.139, 0.139. So our legal limit is 0.08. His level was 0.139. So he was beyond the point of intoxication. At some point in the night, Christian Daniel Herrera left the premises to drive his vehicle. Christian Daniel Herrera was served alcohol in excess at 13 by James Harden. He was served past the point where he was obviously intoxicated to the extent that he presented a clear danger to himself and others. Christian Daniel Herrera disregarded a red light and T-boned the vehicle. Taylor Jackson was a passenger in. Taylor Jackson ultimately was unalived because of the injuries she sustained in the collision. Plaintiff reserves the right to amend and supplement. So if they find out any other additional details about that, then it will be amended in this complaint. So I always put this because if there's more information that is going to be provided, I make sure that I put this language in here. Plaintiff reserves the right to amend and or supplement as allowed by the Texas Rules of Civil Procedure. Causes of action. Texas Survival Statute pursuant to Texas Civil Practice and Remedies Code, Section 71.021. The plaintiff herein, which is Cassandra Jackson, is becoming the legal representative of Taylor Jackson's estate, which means that she has a probate case. Taylor Jackson has had a cause of action for personal injury prior to her death, and she would have been entitled to continue pursuing that cause of action had she lived. Unfortunately, Taylor Jackson passed away. Taylor Jackson's death was caused by wrongful acts of defendants as described more thoroughly below. So she already had a personal injury case that was ongoing before she passed away. B. Texas Wrongful Death Act pursuant to Texas Civil Procedure and Remedies Code. The plaintiff herein, Cassandra Jackson, is the biological mother and statutory beneficiary of Taylor Jackson. Defendants are corporations. The defendants' wrongful acts caused the death of, the unaliving of Taylor Jackson. Taylor Jackson was entitled to bring a cause of action if she had lived. The plaintiff suffered actual injury. Hold on, let me read this. Had a cause of action from okay, so I'm not saying if they're saying that if she did not pass away, that this would just be a simple personal injury case because of the car wreck, or if there was already a pending case in another personal injury matter. So I need to look at that. C, and these are the causes of action. Texas Dram Shop Act. So plaintiff brings suit against defendants pursuant to the Texas Dram Shop Act, which is the Texas Alcohol Beverage Code, annotation section 2.01-2.03. Defendants were providers of alcohol for profit. Defenders had a statutory duty to refrain from providing alcohol to obviously intoxicated person. Defendants, buying through agents, servants, staff, managers, and/or owners, violated the Texas Dram Shop Act for financial gain and served Christian Daniel Herrera while he was obviously intoxicated to the extent that he presented a clear danger to himself and others. Texas Dram Shop Act defines a provider as a person who sells or serves an alcoholic, supposed to be an alcoholic beverage under the authority of a license or permit issued under the terms of this code, or who otherwise sells an alcoholic beverage to an individual. The Texas Dram Act, the Texas Dram Shop Act defines a provision as including but not limited to the sale or service of an alcoholic beverage. At all relevant times, defendants were in the business of selling alcohol and did sell and or provide alcohol to Christian Daniel Herrera on the night made the basis of this lawsuit. Defendant falls under the definition of provider. The intoxication of Christian Daniel Herrera was the proximate cause of the damages suffered by plaintiff. The following acts and omissions were a violation of the Texas Dram Act, Shop Act, and were a proximate cause of the plaintiff's injuries. So, serving alcohol to Christian Daniel Herrera was apparent to the provider that he was obviously intoxicated to the extent that he presented a danger to himself and others. So, if you see that a person is falling over, doing the most, that is a clear indication that you should not be serving anyone any type of alcoholic beverage at that point. But, I've seen this in the movies. They be like, well, he's paying, so I'm going to keep, serving. It should not be that way. It really shouldn't. Failing to require all employees to attend a commission approved seller training program. And I'm assuming that the program actually tells them this. Oh, I need to save this because I need to enter that in when we do have cases like this. Failing to have all employees engaged in the sale, service, or delivery of alcoholic beverages, as well as the immediate managers, Texas Alcoholic Beverage Commission approved seller, server certified, directly or indirectly encouraging employees to violate the Texas Dram Shop Act, failing to implement the Texas Alcohol Beverage Commission's recommended practices, failing to have written policies and procedures in place regarding the responsible service of alcohol to patrons, failing to track and record the number of drinks served to a particular patron, failing to have a system in place to track and record the number of drinks served to a particular patron, and other acts and omissions that may be shown at the time of trial. So that means I've never been a waitress, a server, a bartender, anything. So I didn't know that they actually have, training in place to where they address these issues, but it's about to come out. Defendants owed a duty consistent with the foregoing and breached each of these duties. These breaches were both a cause and in fact and proximate cause of plaintiff's severe injuries. Each of the foregoing acts and or omissions taken together or individually were a violation of the Texas Dram Shop Act, and each proximately caused the collision and the injuries and damages sustained by the plaintiff. Now, the vicarious liability. So, plaintiff is of information and belief that defendant failed to comply with the Texas Alcohol Beverage Code Section 106.14, and defendant is responsible for the acts and omissions of its employees. So, you gotta be careful. See, them employees will get you in trouble. I'm pretty sure that Buddy doesn't have his job anymore once they got wind of this lawsuit. Now, vicarious liability in Texas is just a legal theory that holds a third party responsible for actions of another person. So that's what we have to include in here because they're suing a third party. It is believed that the defendant directly and indirectly encouraged employees to violate the Texas Dram Shop Act by paying an hourly rate that was very minimum and requiring service to rely on tips from the large bar tabs that consisted predominantly of alcoholic sales. So, what they're saying here is that the defendant, who is the restaurant or whatever it is, a bar, restaurant, right? They pay their servers, bartenders the bare minimum to where they're like, oh, this person, I don't care how much they're drinking, I'm gonna keep paying. I'm gonna keep paying. I'm gonna keep giving them drinks if they keep paying. There we go. So that money is steady coming in. They're working off tips because you think the more a person drinks, the bigger the tips be. So do you really think that somebody really cares or not if that drunk person gets in their car and causes a collision? Some of them do. Some of them do. But majority of them, if I'm getting paid $2 an hour and I know I got a bill due, I'm going to work and I'm going to continue to serve until I reach however much money I need. And this is what I'm just thinking out loud. The individual who provided Christian Daniel Herrera alcohol when he was obviously intoxicated to the extent that he presented a clear and danger to himself and to others were the agents, servants, staff, managers, and/or owners of defendant. Accordingly, defendant is vicariously liable for the acts of said individuals. So these are standard damages. As a direct and proximate result of defendant's negligence, the estate of Taylor Jackson suffered the following: past physical pain and suffering, past mental anguish, past physical impairment, past disinfringement, past reasonable and necessary medical expenses. Can't be any future because unfortunately they're not here with us anymore. Funeral expenses, as well as actual damages allowed under the law, and such other and further relief as the court may deem just and proper. As a proximate result of the defendant's negligence, Cassandra Jackson suffered the following damages. So, as a parent, this is what she suffered: the loss of Taylor Jackson's advice, of her counsel, her services, her care, her maintenance, her support, her companionship, her society, loss of inheritance, past and future mental anguish, exemplary damages, prejudgment interest, post judgment interest, and cost of court. Plaintiff is also seeking both prejudgment and post-judgment interest, cost of court, actual damage, and all other relief, both in law and in equity, to which plaintiff may be entitled. And then they have a clause to where, anything that regarding to this incident needs to be preserved, and if you don't preserve it, then you're going to be sanctioned. And they're also asking for a jury trial. And let's see what else. And they have provided their disclosures. So this is information that they're wanting upfront. And this is actually due 30 days. So once they get served, they have 30 days to actually respond to this. Discovery request production if a party does not produce copies of all responsive documents electronically stored. Yeah, so that's all it is. They're asking for the disclosure. So as soon as they are served a copy of this petition, they have to get disclosure, which I'm not going to go over the disclosures, but normally you have to provide you have to provide certain documents to the opposing counsel, which would be the plaintiff, and vice versa. The plaintiff would actually have to provide that information over to whatever counsel defendants decide to have. Now, for the plaintiff, their disclosures is going to be a little bit more detailed because she also is going to include, she has the proof of her damages. So her damages would be the medical records, medical bills, funeral expenses, death certificate, or anything that has been associated in regards to this incident. And that is all. Oh my gosh. So it's really a tragic situation. But I hope that justice is served. As the article did state, the drunk driver was unalived also in the crash. And so normally what happens is you would go after that individual's insurance company, but if they do not have, here's how it works, and this is just for Texas. I've done Florida and Georgia, but for Texas, this is how it works. So if you have a minimum policy, um and there was no other coverage or no other defendants, then you would just have to suck it up and take that policy of the at fault driver. In this case, because it's a third party who issued alcoholic beverages to an individual who was clearly intoxicated, they're also going after them as well, in which they can rightfully do so because they do hold some type of responsibility. So they could have, gotten all of the insurance information, not information, the what am I trying to say? They could have collected on that individual insurance policy, but it was not enough to cover all expenses. And they would then go to, now, this individual was a passenger in a vehicle. So if this vehicle actually had, let me see, if they had a policy, depending on however much policy they have, they can collect on that as well. But even if that's not enough, then they'll go to the third party. But at the end of the day, I'm going after everybody who was in part. It sucks that I was in the car with this individual, but I'm still going after their policy, and I'm still going to go after the drunk driver's policy and the responsible party. So in these wrongful death cases, when you're dealing with drunk drivers, and God forbid anybody who is listening to this that ever happens. But if you go into a lawsuit, well, here's the thing: if you go speak with a lawyer and they want to do this pre-litigation, no, we're not sending no demands, we're not doing none of that. We're going to file suit immediately. That's what you need to do. So prayers to Miss Cassandra during this time. I know nothing can ever bring her child back from this. I know that it's really difficult because now this is another, holiday that you have to go through without your child, and no parent should have to go through that. So my condolences out to her and all of the victims who were involved in this tragic incident. But yeah, so it's very, how can I say this? There's rules and regulations that these bars and gentlemen's clubs and any business that actually, sells alcohol, there is a standard that they have to uphold. There's certain training that they go through, so they know how to conduct themselves, what to do, what not to do. So you have to hold them accountable. But y'all tell me what y'all think about, James Harden getting. I don't even know if he's ever been in a lawsuit, but y'all tell me what y'all think about this. I know it's quite different. But in my opinion, she deserves everything because, like I said, she can't bring her child back, but she can get justice on behalf of her. So y'all tell me what y'all think about this in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed and have a good night. Bye.